Welcome everyone to Legal Issues During the Pandemic Crisis, hosted by the Center for the Women of New York. My name is Victoria Pilotti. I am the president of the Center for the Women of New York, and we have been empowering women to achieve full equality since 1987. Since our founding in 1987, we have shown that women working together can be an effective force. We are a voluntary nonprofit organization, and we do exist on dues from our membership and volunteer efforts from the community. We advocate strongly for women's full equality by partnering with like-minded organizations. We believe education is the cornerstone of women's economic independence. Whether we're marching for worthy causes, celebrating women's accomplishments in leadership, the arts, or sports, camaraderie is a hallmark of the Center for the Women of New York. We've come a long way since the second wave of the women's movement in the latter half of the 20th century. And we still have a long way to go, but together we can accomplish anything. So now, if you would like this PowerPoint, it is on our website, cwny.org/past-events/. And together with the PowerPoint, you will be able to download resources from the expert attorneys who are our panelists. So slide 4, please. Oh, okay. All right, so I have to put the slides up.
Good morning, Ann.
Good morning, Jacqueline.
How are you?
Good morning, Victoria.
Good morning.
So I wanted to just say while we're waiting that I'm very excited to do this presentation, and after we have the slides up, Ann is going to be going first, and I'm going to be following her and talk about a tough act to follow.
No.
Can't wait to hear what you have to say. Thanks, Ann. All right, back to you, Victoria.
Our panelists will address advanced directives such as healthcare proxy, living will, and DNR. And I challenge most of you to know what DNR stands for, but you will find out shortly. A DIY will or use a lawyer. Future of long-term care. Trust to protect one's home. Co-parenting in captivity. Divorce mediation. Joint custody. Child abuse and neglect. And an update on family and Supreme Courts during this time of COVID closures. Our panelists are Ann-Margaret Carrozza, offices of Ann-Margaret Carrozza, Jacqueline Harounian, partner Wisselman, Harounian, and Associates. If you have any questions, please use the chat box at the bottom of your Zoom screen to ask a question. If you dialed in, email your question to events, EVENTS, @CWNY.org. Your questions will be addressed after the last panelist's presentation. Again, if you dialed in, EVENTS, @CWNY.org. The law offices of Ann-Margaret Carrozza provide estate planning, elder law, and asset protection guidance to families and individuals, as well as guardianships, will contests, and Medicaid applications.
I think we can skip the bio.
Yes, you will have this in your PowerPoint.
Okay.
But I do want to say that Ann-Margaret is well esteemed and invited to present on the very same topics she will be addressing here on national television. So we are very honored to have her. Thank you for joining us.
Thank you.
Okay.
Okay, so I would just like to start, Victoria Pilotti, President of CWNY, thanking you for your innovative efforts to bring content and really important information out to all of us. That's what the Center for the Women of New York is all about, and you are dragging me kicking and screaming into the new millennium with this technology. So thank you so much for that. You know, one of the effects of this unprecedented era that we're in right now is that we can't help but think about sickness. We can't help but think about our own mortality. Not all of that is bad. We're rethinking how we want our lives to be on the other side of this. Where do we want to live? What do we want our professional lives to look like? So I think it's, you know, part of it is a great opportunity to redefine our lives, redefine, you know, what happiness means to all of us. And I think part of that is realizing that life is finite, realizing that we're all terminal because we're human beings. What do we want between here and there to look like? And that's on us to redefine and refocus our happiness and what we want our next steps to be like. But also, how do we want to leave things for generations behind us, our children and our children's children? When we think about healthcare and long-term care, we really need to dust off the documents that we may have done years ago. Healthcare proxy, power of attorney, living will. These are critically important documents to have in place, and they can really save a lot of stress and anxiety for our family in the event that we can't speak up for ourselves down the road. So we start with a power of attorney. Power of attorney allows the person or people, we can have one or two agents on a power of attorney, to make financial decisions for us in the event that we're not able to. It is a potentially powerful document, and we need to be very careful with the power of attorney. I don't recommend downloading a form or buying a form at Staples. There's a lot of room for error with the power of attorney. Way back in time, a power of attorney was a one-page document, and you kind of gave the agent all of the powers in the world. Rewind to, I think it was around 2007, there was a very bad guy who convinced his aunt to give him power of attorney, and he took the document around town to all of her banks, emptied them all out, put all of the money into his own accounts. She died, and her will said that all of her assets got split 5 ways. The only problem was there were no more assets to split because the bad nephew helped himself to everything. So it was a contested court case. He pointed to the box on the power of attorney where the principal purportedly did give him the ability to make gifts to himself. In all likelihood, she had no idea what she was signing. So I was a New York State legislator at the time, and in 2009, we drastically overhauled the power of attorney law in New York State, and then it was refined again the following year. Now, if we want our agent to have 100% authority over our business dealings and assets, we have to do not only the main power of attorney, but also something called a gift rider. Why would I ever want someone to be able to make gifts of my assets if I'm incapacitated? Well, if I have a long-term illness and my husband is my agent under the power of attorney, yes, I would want him to be able to make big gifts of my assets, to get them out of my name and gift them to himself so that they're not lost to $15,000 a month nursing home costs. This is a little bit beyond the scope of the advanced directive piece, but I really want to emphasize we should all have a power of attorney in place. But if the agent or agents that we're appointing under this document, if we don't trust them 1,000,000%, if it's sort of like a distant niece, or I'm appointing my attorney or my accountant or my financial advisor, maybe I want to narrow the scope of powers that they have. So it's an important document to have. It's more important to have it done correctly. Now we come to healthcare proxy. So the healthcare proxy is a document that allows us to name another person. This document cannot have two people acting together. So that's the only room for error with a healthcare proxy. I can't name Mary and Susie to make my healthcare decisions. I can name Mary number 1, Susie number 2, and that document is legally binding in a hospital. It means that the hospital must listen to the directives of the person I've named under the healthcare proxy. Living will is a little bit different. New York does not have a very strong living will statute, unlike other states such as Florida that do. New York's health law says that a living will is some evidence of what the principal wants. So I tell my clients that the living will, you can put whatever the heck you want in it to inform your agent under the healthcare proxy. So in my living will that I have on my website, myelderlawadttorney.com, I put in there a preference that says, in the event that I need long-term care, I wish for the care to be provided in my own home. You can customize the living will any way that you choose. You can put your favorite foods in the living will. You know, if at a future point in time, I'm not able to communicate, I am guessing I will still like pizza. So if I want to make sure that I have the stuff that I like and I'm in the environment that I want to be in, those things should go into the living will. DNR, we've all heard that term, and I can't tell you how many people come into my office asking for a DNR. You cannot do a DNR in advance, even if you wanted to. So DNR stands for Do Not Resuscitate Order. It's only applicable in a hospital setting. And what it means is, in the event that maybe I'm on hospice care or palliative care and I don't want heroic resuscitation measures, I will sign a DNR. So it's kind of like a narrow band of people that are sick enough for the hospital to be giving this as an option. You know, would you like to sign a DNR today, Anne? 9 times out of 10, when the question comes up, should the patient have a DNR, the patient themselves is probably not in a condition to sign it. If I have a DNR from a prior hospitalization, they probably will not let me use it. They want a fresh DNR for that spell of illness at the time. So whoever I have appointed as my healthcare proxy agent can sign a DNR at that future point in time. So again, it tacks back to the healthcare proxy. critically important to have. And another advance directive that we may want to consider when a patient is at home, palliative care at home, hospice at home, and we don't want, you know, a 911 call to potentially bring me to the emergency room for cardio resuscitation. We want to ask our physician for yet another type of healthcare directive, and this is an acronym, MOLST. A MOLST form you get from your physician, and it's brightly colored. You put it on your refrigerator, and the EMTs and paramedics are trained when they respond to a 911 call for an elderly person. They check the refrigerator, and if there is a MOLST form there, they will not cart the patient out to a hospital setting. So those are the basic advance directives. We can go to the next slide. So should we do these documents ourselves, or do we need an attorney to do the documents? So I think the answer is somewhere in the middle. There's no shortage of legal document preparation companies online. Celebrity financial gurus sell these packets online. And I think some of the documents, a healthcare proxy, for example, I always say that I think an attorney should be ashamed of themselves for charging a client for a healthcare proxy. There is zero room for error in executing a healthcare proxy, with the exception of you can't put Mary and Susie together, but you have one primary, one backup, no room for error in a healthcare proxy, and I believe that's one of the resources that we're going to give to all of the participants of today's webinar. So healthcare proxy, you don't need a lawyer for. Even a living will, I don't really think you need a lawyer for. You're free to copy the template I have on my website. You can add to it and then put a Post-it note on it that really the living will is for the eyes of the family to make a group decision. Maybe it's a shot of courage during a difficult time. Can and should the will be a do-it-yourself project? I really don't think so. So a will kit, and some of the companies brag that in the time it takes to order a pizza, you can have a will. I really think we need to put a little bit more time into doing a will than we do ordering a Domino's pie. The will kit can determine who gets my stuff, right? So they're gonna give me fill in the blank. So Mary, Susie, and Johnny get all of my stuff. We can do that within a will kit. But what are the chances that none of my beneficiaries have a problem? If my beneficiaries haven't spoken to each other since Thanksgiving 1998, then chances are they're not going to play nicely in the sandbox together when it comes time to administering the will. So if there's any friction between beneficiaries, if any of the beneficiaries have a problem, a developmental disability, they spend money like a drunken sailor, they're on their fourth marriage, whatever the problems are, and I challenge anyone to tell me that you don't have anyone in your family with any of these problems. I think we all have varying levels of dysfunction in our families. And those issues really come out when it comes time to administer the will. I loaned a daughter $50,000 for the down payment on her house. Everyone's sort of forgotten about it, but her brother and sister will not forget about it when it comes time to administer the will. Was that supposed to be an advance against her share of the inheritance? So, you know, again, when there's any level of complexity or dysfunction, or we're in a blended family situation. I think that's more than half the people are in some type of blended family arrangement. If my new younger husband hates my adult children and vice versa, they will have a war when it comes time to administer the will. So I strongly recommend that people have an attorney to go through the will process to flag issues that you might not have thought about, and we can very easily draft around them and really customize the will. So I hope that people get away from thinking about who gets my stuff when I die, and we want to think more about how they get my stuff, right? I might want my son to have a third of my estate, but if he hasn't worked in 20 years and he's watching game shows all day, he has probably not saved anything toward his own retirement. So his 1/3 of the estate should go to him maybe 5% a year for 20 years. You can't do that with a do-it-yourself kit. Okay, next slide. The future of long-term care. So a definite consequence of this unprecedented economic onslaught on both the federal and the state level means that programs we've relied upon for decades are going to look drastically different. And when we're talking about long-term care, in New York, especially in the New York metro area, where the monthly cost of nursing home care exceeds $15,000 a month, if we don't do some planning ahead of time, we will end up in no time at all blowing through all of our assets, and then we're on the Medicaid program. Well, Medicaid has eclipsed education as part of the New York State budget. So prior to the pandemic, New York State was looking at a $6 billion deficit, and they implemented in the recently passed New York State budget some strictures making it more difficult to qualify for the Medicaid program. Some older folks may remember that the so-called look-back period during which we could protect assets, and then you had to wait a number of years before being able to apply for Medicaid benefits. That look-back period used to be 3 years, and in response to federal budget constraints, it was lengthened to 5 years in 2006, and there have been bills kicking around in Congress that would make it either a 7-year look back or a 10-year look back. But in the face of the budget deficits caused by COVID, we can be sure that this so-called look back period is going to be lengthened. People who do their planning under the current regime, which is a 5-year look back, should be grandfathered. There are constitutional issues with making a change in the law that is retroactive in effect. So people seeking to protect assets, and we can go to the next slide. We want to do this 5 years before we have a problem. And I hope it should go without saying that the way to protect one's home is with a trust. It's not simply putting the house in the kids' names to protect it from my future possible nursing home stay. If I take my house and I want to keep things simple, I don't want to pay a lot of money to a lawyer, and I go to the guy down the block and he does a new deed putting the house in the 3 kids' names, that's a very big mistake, because number one, I will lose any star property tax relief that I may be getting. The kids are going to take it with a carryover basis for capital gains purposes. That means if I bought the house in 1978 for $50,000 and it's now worth $650,000, if my kids are nice and they do let me live there for the rest of my life, and then they go to sell it, they're going to have tremendous capital gain. So we don't even want to think about putting the house in the kids' names. They could be the nicest people in America, not even thinking about them kicking me out, but there are going to be tax consequences. So we definitely need a trust to protect the home. Should it be revocable or irrevocable? And the answer is no, because a revocable trust, it's also called a living trust, that's very appealing psychologically. There are tons of seminars all over the place. My mother and her friends used to go to them for free refreshments. But a revocable or living trust is very appealing because we don't lose any control, right? It's revocable. I can put my asset in, I can take my asset back out. It's terrific. I haven't given up any control. But think about it. If I put my asset in and I can take it out at any time, do you really think that is protected at all from a nursing home or other liabilities? And the answer is, of course it's not. A revocable trust avoids probate. If that's your only goal on this earth, then the revocable trust is for you. But if we want to avoid probate, but also protect the primary house, the primary residence from long-term care claims, and we want to start this magical 5-year clock ticking, then it needs to be a stronger trust. It does not, however, have to be totally irrevocable. This trust, I call it an asset protection trust. It's a hybrid. I put the asset in, I can retain 100% of the ownership rights, the use, and the occupancy. The only difference between the asset protection trust and the revocable trust is I must put someone else in there as my trustee. So let's say I put Victoria in there as my trustee. If the trust is properly drafted, I will retain veto power over anything that Victoria may want to do. So if it's properly drafted, she can't look right and she can't look left without my written permission. The only time I need my trustee is in the event I wish to sell the property. She can't sell it without me, but I cannot sell it without my trustee. So playing devil's advocate, not that Victoria would ever be anything other than lovely and gracious, but let's say she was on a cruise, she was on a lovely swanky vacation and was not available to give her signature when I wish to sell the house, then I can very easily, without her involvement, I can pull her out as the trustee, and I can put Jacqueline in there as my new trustee. And you can keep swapping out who the trustee is until you get a yes man or a yes woman. So having that bouncer at the door, so to speak, that third party as the trustee does enable me to say to a nursing home 5 years from doing it and to a garden variety plaintiff, a guy trips and falls on my stoop, I'm able to say legally that I, acting alone, can't get at it. And in that case, if there is a plaintiff coming at me, now I don't want my trustee to agree to allow the property to come out. So, it's a little bit artfully drafted. And when we come to who the beneficiaries of the trust are, and my kids are Mary, Susie, and Johnny, then I can also modify how they receive the asset. Does Johnny need his 1/3 to be in a supplemental needs trust, or his own asset protection trust, or a spendthrift trust? So really think about customizing your documents, and don't let the word trust scare you. If you're an active participant in creating this trust, you can come up with something that is very flexible, but strong enough to protect the whole family. And that's what this is about. Good estate planning, thoughtful estate planning is really a gift to the kids, because when a parent dies and the kids call me at my office saying, well, we have to come in for the estate administration, and I check the file and say, you know, mom did a trust 10 years ago. I send them a condolence card, but they have no need to come into my office, no need for an attorney, and everything is 1, 2, 3. And the kids are moved. It's like a final gift to the kids, the thoughtfulness to go the extra step to arrange everything very nicely. So that's the end of the specific info. And then I guess at the end of Jacqueline's presentation, we'll all open it up to Q&A.
Before then, I'd like to see who was awake and retaining information. Here we go. Test.
Oh boy.
A trust sounds too complicated. Can't I simply put my house in the kids' names to protect it from future possible long-term care expenses? So take a second. Is the answer yes or no? Let's see if you were paying attention. Absolutely not. And on our website, we have all the explanations of these answers. So when you download the PowerPoint, you can also download the full responses to these questions. Hope you got it right. Does a living or revocable trust protect one's assets in the event that long-term care is needed? No. Is it possible to protect one's assets without using a totally irrevocable trust that can never be changed? Yes. Will a revocable living trust protect the house? Uh-oh, I hope you didn't answer yes. You'll be in big trouble. You'll be homeless. Does irrevocable mean that nothing in the trust can be changed? Now, I was really paying attention to this one. I know the answer without peeking. So I hope you did well. I hope you got 5 out of 5. If you didn't, or if you're confused by the responses, the answers are on the Center for the Women of New York website at the events part of the menu, and then you click down to past events. And we'll give that to you in another slide in a minute. But now we have Jacqueline Harounian of Wisselman, Harounian and Associates. Jacqueline is a partner of the law firm, and she also is gracing us with her presence. She has written articles, she has written a book, and she is listed as a top-rated lawyer. So without further ado, Jacqueline will speak to us about family law in captivity. Thank you, Jacqueline, for agreeing to help us.
Of course. Good morning, everyone. And for all of you that are listening to this live on the webinar or elsewhere, or might see it as at a future time if we broadcast it for the Center of the Women of New York, I want to welcome you all and invite you to find out more about proactive ways that you can protect yourself and your family. I want to say thank you to Victoria and the Center for Women of New York, which is an amazing organization. I invite anyone listening to find out more about it and to get involved and to support the organization. And I also want to commend Victoria, who's the current president, for really taking the lead in planning these webinars, which have been very well attended and very well received. Last week, we did one on domestic violence. We had over 100 people participating. And this morning, we're talking about legal issues during the pandemic. And I have to say, and I'll say it again, Ann-Margaret Carrozza is a very tough act to follow, and please be gentle with me in your comments because I'm definitely not in her league when it comes to
Oh,
presentations.
stop.
Just as a housekeeping matter, because my firm is sponsoring and we have the Zoom set up, there is a question and answer link that you can easily find if you're on the webinar, and very easy to submit a question. And there, all the questions will be answered. And if you submit questions on other ways, on Facebook or on the email, we will make every effort to answer the questions. And there's also a chat feature. So as Ann-Margaret was speaking, I was struck by how many similarities there are between family law and estate law. Because we are also dealing with families, we're also dealing with family issues, we're dealing with husband and wife or partner issues mostly, but also people that are under stress, sometimes in crisis, and not always on the same page. And people that used to really have strong feelings for one another. In every case, very similar to estate planning, you want outcomes that are fair. And you want to make decisions that are based on rational decisions, not emotional decisions. And so the way to have that in family law is to do it in a proactive way. And to do it at a time where you're not being driven by anger and emotion. And so this is the challenge for family law attorneys. Most often we're meeting with people that are coming to us in extreme crisis, feeling betrayed, feeling upset, and feeling uncertainty. And, you know, for those of us that have never been in a family law situation, and I would count myself among those people, I get a little sense of what that feels like right now, actually, because now living at home full-time with my husband and my adult children who have come back home and dealing with all the uncertainty at work and in, you know, everyone's personal life, dealing with health issues and financial issues, we are all getting a taste of what it feels like to really be in crisis mode as a family. And so you can magnify that tenfold or 100-fold for families that are in a family law crisis, that are dealing with parenting conflicts, that are possibly contemplating separation or divorce. Maybe they were doing that a month or two ago in the old days before the pandemic, or maybe they're dealing with it right now. They're stuck at home with someone they really don't care for very much, or maybe are even fearful of. And all that uncertainty and stress and financial stress and homeschooling and, you know, who's doing the housework and the laundry and the stress of just going to the supermarket. We have families that are in extreme crisis right now. And these are the calls that the attorneys in my office are getting right now. Families in crisis, co-parents that really don't know what to do with their agreements and their court orders because you really can't follow them right now. And what goes on in the court system when the courts are effectively shut down, they really ground to a halt, except for a few different matters. And I'm going to talk a little bit about that because this is our new reality. I can't imagine that any of us are going to walk into a courtroom anytime soon. It'll probably be months. So how do you deal with that? You can't put your life on hold. So with the goal of being proactive, with dealing with things in a way that's calm and measured, and if there are children, in the best interest of children, then my presentation is really hopefully going to be helpful to many of you. And to also repeat something that Ann-Margaret said, which is very, very true. In the divorce law field, in family law, we also have celebrity gurus that are online and have websites and selling do-it-yourself divorce kits or family law agreements. And those are extremely risky. I'm not going to say they can't work for some people. Everyone knows I'm sort of an outlier in my industry. I'm a big fan of uncontested divorce and mediation and simplifying things. But there's a risk to doing it yourself and trying to handle these complicated issues on your own. And many people attempt it, and boy, they pay a price. So I'll give you a recent example. I had a client a couple of months ago who came to us. She signed an uncontested divorce with her ex. They went to a very inexpensive paralegal agency that charged very, very little, and I understand how people are attracted to that. But she signed off on something that she thought was joint custody. She didn't understand that because her daughter was temporarily living with the father as a teenager, but was going to come back to her, that was the plan, that she had signed away temporary custody of her daughter. She thought she had joint custody. The agreement, in fact, said that. But it also said that the child would live with the father. And it's very hard to undo a physical custody agreement, especially with a teenager, and most especially not understanding the implications of what you're signing. Had the client come to us for a free consultation, we always offer information and advice. It's not always about getting paid upfront. Sometimes you just need guidance. But had she come to us, we would have said, this is what you're about to sign. This is what it means. And this is how difficult it's going to be to undo what you just is the thing. And now with the court system shut down, she's in agony right now because she cannot undo something that she thought was very easy, do it yourself, that she signed a year and a half ago. So, you know, Anne mentioned drunken sailors and dysfunctional people and all kinds of things that come out of the woodwork in a family law situation. And of course, we have our share of people that are in distress. When people go through marital dissolution, when they're under stress, and again, we can all relate because we're in captivity too at home right now. It's very easy to lose your bearings. There's a lot of mental health challenges, a lot of stress and anxiety. And unfortunately, matrimonial and family law really brings out the worst sometimes in some very nice people. And matrimonial practitioners, what we say is that family law is really good people, sometimes acting their worst. These are not bad people. Most cases settle down. Most people that we deal with a few weeks, a couple of months into the process really are able to focus on the rational, proactive aspects of doing what's best for their children and their families. So I want to talk a little bit about what the options are right now. And I see we have a slide up, thank you, Victoria, regarding what can be done for what I would say is 80% of you listening, 80% of the public at large that really is able to act in good faith with their ex, recognizing the needs of their children and open to reasonable legal advice. For that 80%, I invite you to find out more about virtual divorce mediation or virtual divorce processes. And many, many family law attorneys are offering it. You can see I'm in my office. Our office is open and operational, but most of our meetings at this point are by Zoom, on phone. We are mediating cases. It's not difficult to do and not that different from what went on before. So this is a time for people that are open-minded, are ready to take on a divorce process out of court. Maybe you want to start talking with your ex about the need to separate. You're like maybe you're in close quarters right now, and you know this cannot last. You need to take steps to separate. Well, you can have a conversation about it. What does that mean? And what is joint custody, which is really the starting point for almost every couple going through divorce these days. And I'm saying the 80%. For 20%, I would say maybe joint custody isn't realistic. Maybe there are severe mental health challenges for one of the parents or the children, or special needs children. Maybe there are specific issues regarding domestic violence or substance abuse. I would say for those cases, divorce mediation maybe isn't the right path, but you should certainly find out what options exist with an attorney to resolve issues anyway. You can still mediate out of court custody agreements, support agreements, and even divorce agreements. So one of the things that has really made all of this a lot easier to accomplish is Governor Cuomo recently passed a number of laws that are emergency orders that are probably going to stay in effect, and hopefully they will, because it was really about time for the legal community to kind of advance technologically. And the main thing right now is remote notary. So everything that Anne talked about a little while ago, even witnessing of wills, can be done differently now that we're all kind of social distancing and you maybe can't come to a lawyer's office. We still need witnesses, we still need notaries, but it can be done if you have identification, and anyone who has questions can contact an attorney like Anne or myself or others that are familiar with remote notary processes. And actually, Governor Cuomo announced the other day, every day he comes out with really inventive and creative solutions that you can actually get a marriage license right now and even get married remotely. So there's a thought for anyone who's thinking they want to move forward. I'm sure most of us listening right now, we've had many canceled weddings, many canceled parties, graduation parties and birthday parties and so many things, and we've all paid a price, and it's really hurtful, and we're all experiencing that. But if you're planning a wedding, there's no reason why you can't go forward and plan one virtually. And it can be very special and sweet and different and memorable. What I would caution is that maybe you want to talk to an attorney about a prenuptial agreement before you get married. There are lots of implications to getting married when it comes to separate assets and marital assets. And we have done virtual prenups. I did my first one over a month ago, right when the shutdown started happening, and it was really exciting, and the couple was very happy, and there are ways to move forward even with prenuptial agreements. So the other thing that I really want to emphasize, and I have always emphasized, because as I mentioned, I'm really a big proponent of civilized out-of-court resolutions, if possible, is the importance for all co-parents to communicate effectively. And that goes whether you're married, whether you're a single parent, whether you're divorcing or separated. There is nothing more important than learning the skill of communicating respectfully and appropriately, and striving always to resolve conflict. Now, whether your disagreement is over something minor in the household, in my house, it's, I'm working, I don't want to come home to a messy kitchen. And I have people in the house that can help with that. So I set expectations, we communicate, and lots of those conflicts are resolved. It's never a good idea to allow issues, whether they're co-parenting issues or child raising issues, or who's doing homework with the children right now, who's monitoring the homework and the homeschooling. It's never a good idea to let those issues fester and escalate with everyone in their own silos, not really focusing on what the conflict is. Avoiding these types of conflicts almost always means they're going to escalate and get worse. And the problem in family law is that when things reach that boiling point, when even people that are not even contemplating separation or divorce really get to the point of crisis, today, you really can't walk into the family court and get an order of protection. What you're going to do is call the police, and that is what you should do if you're feeling unsafe. If someone in the household is acting in a manner that is truly threatening and dangerous, you're going to call the police. And the police have to do what they have to do. If there is evidence of an assault or a threat, you might end up arrested. Your ex might end up arrested. Maybe it's both of you that are in conflict. These are really serious issues. And victims of violence, men and women of all ages, have to be protected. And the important thing is that you deal with these issues proactively and reasonably, and not get it to that point where there's distrust and anger to the point where it really becomes a problem. I guess you can go to the next slide. And just going forward with that concept of domestic violence, that is really a situation where mediation doesn't work. Mediation can't work when you're afraid of the opposing side. And so I just want to put that out there. If you are feeling fearful or intimidated, then mediation is not going to work. So this next slide talks about co-parenting in captivity. And this is really the issue for the day. I'm talking about this a lot. I blog about it. I've been on a couple of podcasts, and this is what really people want to hear about, is what can people do if they are in a family law situation and their agreement just is not workable. For example, we have joint custody agreements where children go back and forth every few days from one household to the other. Well, what if you have one household where one of the parties is sick? There's a risk to children. There are children with medical issues. There are parents with medical issues. And above all, you know, these agreements have to safeguard the welfare of children and especially their health. So it might not make sense to go back and forth on weekends for overnights right now. And that causes a lot of difficulties because we have parents calling us every day that are being denied their parenting time. They want to have time with their children, and the other parent is like the gatekeeper saying, well, I'm not letting you. That's not acceptable. That's not the way these agreements are supposed to work. And probably in the future, when attorneys start drafting new divorce agreements and custody agreements, we're probably going to have, at least I would put, a force majeure or a pandemic clause that in the event of a pandemic or a crisis, what do parents need to do? Well, what they need to do is work with each other, be flexible with each other, because you can't run to court now and get these agreements enforced. You just can't. And the police aren't necessarily going to be that helpful either. So when I get these calls, and I've gotten dozens of them over the past month, I'm encouraging my clients and future clients, and even the advice I give on Facebook, because I can get active there in the mommy groups. You have to reach out to the other parent. You have to explain what it is that you think the problem is regarding the child going to the other household. Maybe it's a matter of having a discussion about wearing masks and gloves, or maybe saying, can you use some Lysol wipes and wipe down your house? Or can you make sure that you're not taking risks when it comes to bringing germs into the house? These are concerns that all parents have. And sometimes the concerns are very legitimate. And there's nothing wrong with getting on the same page, trying to have a dialogue about what's truly in the child's best interests. Is it okay for the child to go for a bike ride in the neighborhood or not? Is it okay for the child to go outside? What are the conditions? What are we concerned about? So these are things that parents should be on the same page about. And I'll go back to that 80%. 80% of parents agree. They don't want their child ill. They don't want their child exposed to germs. They want to make it out of this alive. And I would even say 80% of parents probably really are thankful that they have a co-parent. They're thankful that maybe they could send the child to the other household for a couple of weeks, because this is a really long time to be in quarantine. And, it's great to be able to have some help. And you can't necessarily have grandparents helping right now. So this is something very positive I'm seeing with co-parenting. I am seeing parents work with each other. I am seeing more FaceTiming, homework help, even extra support being paid. Parents are working together. And maybe this is one of the takeaways, maybe one of the silver linings about the situation. Maybe this will be a tipping point where co-parenting and joint custody really will become a real thing and not just a label that we use to kind of resolve disputes. I always tell my clients, even the ones that are very angry and upset because there's been infidelity and they feel betrayed, I tell them, especially if you're a working mom or a working dad, it's great to have a support system. It's great for your child to have another parent who loves them, another set of grandparents and family that really care about them. Really lean into that. And this is the time. So this should be the mindset. And parents that are working from home, that have to deal with their own work responsibilities, dealing with their child homeschooling, dealing with health concerns, financial concerns, loans from the government, stimulus checks that may or may not show up. This is a time to work together. And if you need to, contact your attorney and get some advice to reduce conflict. There is advice out there. So item C on this slide is an issue of concern. It's child abuse and neglect. And so many of you know that I have a very strong partnership, my firm does, many family law attorneys do, with the Safe Center on Long Island and with other victim services agencies that I could name. Shalom Task Force, Safe Horizons. I'm very involved with UJA Hope Against Domestic Violence. And there is a huge concern, and we learned about it last week during the webinar with CWNY, that child abuse and neglect and domestic violence, the calls to the hotlines are actually lower than before, which is very concerning. Before, when children went to school, when they were out in the public, when there was an abuse concern, there were mandated reporters, social workers, teachers that would call the hotline and get help for those children. Now that is not happening. Children are stuck at home with abusive parents, being neglected, and same goes for domestic violence victims. I recently heard from Josh Hansen at the Safe Center. He's the director there, and he says calls to the hotline are down. And that doesn't make sense, except when you realize that victims really can't pick up the phone and call. They're afraid. They're trapped in the home with their abuser. They're waiting for this crisis to be over, like we all are. And what I think is going to happen, and which is very widely predicted, is that when the pandemic is over to the point where people are resuming normal life, we are going to see a spike in calls to the victim service agencies, to the hotlines, and to divorce lawyers, because lots of people are in crisis right now and they're just kind of holding it in. And that's in a way what we're all doing. We're just kind of waiting for this to be over so that we can move forward. And there's a lot of advice that we shared during last week's webinar on domestic violence, proactive advice for victims if they need help. And I'm not going to go into it in detail today because that really is a whole other webinar that we did last week. But anyone who wants information, resources, all you have to do is contact CWNY. Victoria will give her email address again in the end, and we'll put it in the chat, and you will get those resources because there are people waiting to help you. There are people that can help you with an exit strategy and help you get some therapy if you need it and help you stay safe. And I'll end the topic of domestic violence just by saying that in the event you are hearing me right now and you are in a situation of violence, ask for help. If you need to, call the police. Reach out to a trusted friend. Don't suffer in silence. There is a lot of help available and you have to ask for it because it's there. So the next topic is teenagers and custody. And this is another area that I really see like a little bit of a boom coming after this is all over. Because teenagers have rights. Actually, all children do. But at the age of 12 or 13, sometimes a little younger, those rights are sort of supersized. And parents don't always understand that. The idea is that she's a child, he's got to follow the schedule, and too bad. And that's not the case. Once children reach a certain age of maturity, 11, 12, 13, around there, if they feel strongly about the schedule, if they would prefer to live with dad than mom, or they want a 50-50 schedule, or they prefer the rules, maybe even the more relaxed rules in the mom's house versus the dad's house, or if they want to sleep late on Saturday, they don't want to go for visits, you have to really listen into what they're saying. And this is something where, again, I encourage parents to really talk to one another, communicate, and really make a decision that's really best for children. So, and that goes double for teenagers. So I still have a teenager at home. I have a 15-year-old. My other 3 children are a little older. And I really have to remind myself that, you know, yes, he's a child. And yes, he's under my care and my husband's care. But teenagers really are very willful. And they do have minds of their own. And they're dealing with a lot these days. I mean, they're really being robbed of all the things they used to take for granted. And I have to, again, go back to maybe it's a silver lining they're going to learn from this. But all of the things with socializing and being in school and participating in sports and clubs and graduations, it's all being taken away. And they're very upset right now. And a lot of teenagers are very angry and anxious right now. And parents have to be sensitive to that. They have to be sensitive to the things they're saying and doing in their children's presence. And they have to take into account if their children want a different schedule. And this disruption of the pandemic, which we're all going through right now, is really going to disrupt families in very, very important ways. And as many of you know, I have a degree in psychology and behavioral forensics. And one of the things I studied, which is so valuable to family law practice, is the concept of family systems. And a family system is not just the 6 people that currently live in my house, but it's the grandparents, it's the cousins, If I had grandchildren, it would be the children. So it's a generation above and a generation below. And every pandemic, major crisis, divorce, change of custody causes ripple effects in the family system. And we are going to see those ripple effects for months and years to come. So we saw it with 9/11, we saw it with Hurricane Katrina and the last financial recession, and we are going to see it again after this is over. So I mentioned domestic violence is for sure going to be something that we find out about, child abuse and neglect. We all know that, we joke about it on Facebook, that people are drinking more. There's more alcohol consumption. There's more coping mechanisms that people are using that probably isn't the most healthy. Those are going to cause problems. It's going to cause family court cases. There are going to be relocation cases when this is all over. People that want to move out of New York that need to move because of various situations, including non-payment of rent, they've lost their house in foreclosure, other financial stressors. So much of that is starting to bubble up underground, and we are going to see it impact individuals and families. And generally that means conflict and even litigation. So you have to be mindful of expecting those things and trying to get ahead of it before it really gets out of control. I know I'm going a little bit over. I have another 5 minutes, so bear with me. Another issue that I really see coming up and we need to really address is vaccines. I'm sure all of you know that in the old days, like 6 months ago, we had all of these major issues with vaccination, and it was really the measles vaccination and just basic vaccinations and all of the disruption it caused in schools and in parenting. And I think back to a case I had only a few months ago that was in family court where we had a judge and we had a hearing scheduled regarding vaccination. And when Governor Cuomo put that law into effect a few months ago, it caused problems because parents were not on the same page regarding vaccinations. Well, now you all know what's coming. We are in the middle of a pandemic. Many, many companies, good ones, bad ones, who knows, are working on a vaccine. And those vaccines are now in trials and being tested. And very likely, a year from now, there's going to be an issue regarding vaccines and whether we are required to take them and whether people are willing to take them and whether children need to take them to go to school. So this is a very good opportunity for parents to really think about that and try to get on the same page about it, because I can see that we're going to have parents in conflict over vaccines for COVID, just like we did a few months ago with measles and other things. So I want to just say another couple of comments regarding the courts right now, and then I'll close. So as of today, and I'm saying today because every day the rules change, and every day Governor Cuomo and the administrative judges and the leaders of bar associations, including the Nassau Women's Bar, where I'm on the board, we are getting updates about what's going on in the courts. And here's what you can expect. First of all, you can't file a divorce right now. You have to wait. Any non-emergency, non-priority court matter, whether it's landlord-tenant, whether it's a malpractice case, a civil lawsuit, or a divorce, you're like in the waiting room right now. We cannot move forward with those cases. The only cases being heard at the moment are what are called emergency cases, and I went into that a lot with domestic violence. You can get in front of a judge on those cases. Emergency custody cases, we have filed petitions for that. You can definitely get in front of a judge for that. And now we are having priority cases, and priority cases are the ones where the judges have cases in the system and they are slowly scheduling Skype conferences. So we have virtual courtrooms, and the virtual courtrooms are now ramping up. So in our office, our 9 lawyers are getting notices every single day from the courts about Skype conferences being scheduled on all of our cases that are priority cases. So if you're not sure if you have a priority case, you need to call your lawyer. You need to find out where you are in the lineup, what I can predict for you, and this is going to really wrap it up and bring me back to where I started, there are going to be very long delays in the system once the system gets fully back up. I don't know if we're going to be in courtrooms or whether this is all going to be virtual, but every case is going to take longer, cost more, and probably cause more frustration. So, perfect opportunity to really consider everything I talked about in the beginning. Mediation, virtual agreements, trying to resolve issues out of court to the extent possible. For 80% of you, that is very realistic to expect. And I really wish all of you the best. If you have any questions, you need copies of anything, please let me know. I am going to be emailing the PowerPoint that you saw today to all of everyone who registered and anyone who sends an NY will also get a copy if they need one. And that's it for me right now. I'm looking forward to answering the questions that we have. Back to you, Victoria.
Thank you, Jackie. So if you have questions, you can use the chat box. If you called in, please send an email to events, EVENTS, @CWNY.org. And while we're waiting for those questions to come in, I'd like to give you another pop quiz. So for what % of divorces can mediation in amicable custody work? Let's see if you were paying attention. If you thought to yourself 20%, you're wrong. It's 80%. So that's very positive that divorcing couples can make good decisions on behalf of their children. I was very enlightened by that statistic. But now let's look at the other statistic. So if you're good at math, the other statistic will come right to your head is 20%. What about that 20%? For which circumstances can't mediation work? I will ask you to think of one, but there were at least 4 that I recall because I was paying attention. So if you thought, well, if there's substance abuse in the home, yes, mediation can't work with substance abuse. Substance abuse changes a person's personality. And as a matter of fact, there are orders of protection that we learned from the NYPD and we learned from Wisselman and Harounian at our in-person domestic violence conference, that there are orders of protection that specify no alcohol consumption in the home. So if that is broken, out you go. So I was very happy to hear about that law because we know alcohol consumption can change someone's personality for the worst. It can make a good person be evil. Next, the next circumstance would be mental illness. Of course, mental illness changes someone's behavior and can create an unsafe situation. So mediation just won't work there. A third circumstance, domestic violence. Yes, again, an unsafe situation for the spouse and for the children. And of course, we have to consider that child with special needs. We can't always make an amicable decision because perhaps one parent doesn't have the skills to really care for that special needs child. So we do need to have outside parties mediating that. And then what I thought was very interesting that Jackie brought up was the question of vaccines. Boy, was that a controversy before the pandemic. I just can't imagine what is in store for politicians, for parents, for pregnant women and fathers expecting his first child. Will they agree on the newborn vaccinations? I just don't know what will happen to families over this issue, and I really thank you for bringing that up. So now let's take a look at the chats.
Victoria, there's 3 questions already in the question and answer tab. If you want, can you see them or I can read them out loud?
Yes.
Okay.
Oh, you can read them out loud. That's fine.
All right. So I'm going to put And if it's okay, the first question is for you. And the question is from Joel Meltzer. Hi, Joel.
Hi,
And
Joel.
do you recommend taking a photo of a healthcare proxy and putting it on your phone, as well as the person who is going to make the decision on their phone?
Joel, that is an excellent suggestion. Some people shrink them and they laminate them and they carry them around. I love the idea of the photograph. Really innovative, and thank you for giving all of us that idea. If we're in a hospital setting and they ask, does the person have a healthcare proxy? 9 times out of 10, they will take someone's word for it, provided that the healthcare proxy is produced, within 24 hours or so, because we normally don't have it on us at 2 a.m. when we're rushed to the emergency room. But I really like the photo idea.
That's great. So now I'm going to actually answer that question myself for a divorce and family law situation. I want people to know that divorce records and family law records are on file at the courts. So if you have a completed divorce or custody order, you can go to court easily and get a copy of it. Maybe not today. I mean, I guess I shouldn't say that. These days it might not be that easy, but it is there. And they're completely confidential. So members of the public can never go and get a copy of your divorce agreement or see what's going on in your family court case. So that's good news. I mean, these things should be kept confidential. However, we often get questions to our office. People want a copy of their documents. And I think the same advice that Ann just gave holds true for our clients. If you have a copy of a divorce agreement, especially a custody order, that you might need to call the police about, or you might need to show someone in authority or show a school, you really should have all those documents scanned and kept somewhere accessible. And this is one of the great things about technology. You can easily pull it up, send it out to who you need to. And just as proactive advice for everyone, these important documents really need to be at your fingertips, whether it's for estate planning, whether it's a copy of your W-2, even copies of your tax returns. There really is no excuse for people not to have these documents available. And I always give a little bit of a special heads up to women, especially when it comes to financial documents. And I really think Ann might agree with me, because we're both part of a women's organization here, that it's important for women to be proactive, to have their eyes open.
Sorry, folks. We lost internet, I think.
For all of us?
It is always dangerous for women to have that dependent mindset, and so they're not involved with those decisions. So thank you for that. And we have another question for you. Are you ready?
Yes.
Okay. The next question is from an anonymous attendee. When you live in more than one, try to guess who it is. When you live in more than one state, for example, New York and Florida, do you need separate documents like a healthcare proxy or living will for each state? Do these documents transfer between states, or are the state laws different enough to require separate documents?
Okay, it's an excellent question, and for 90% of the estate planning documents, there is no difference between states. So the Constitution, the full faith and credit clause, provides that one state must honor the other state's law. However, as a practical matter, I tell my snowbird clients, you are better off when you're in Florida to have a Florida-specific power of attorney to show the banker, so you're only waiting 45 minutes as opposed to 2 hours, while they have some 3 levels of review for the New York power of attorney document. For your bigger documents, for your trust, for your will, there's no difference at all between states, so you don't have to redo them. The healthcare proxy is good in all 50 states. the living will, as I alluded to earlier, Florida does have a very different reliance on the living will. I would do a separate living will in Florida and go easy on, you know, your food preferences, and I like pizza in it, because in Florida you can give the living will to a hospital and it has an effect on the treatment.
Wonderful, thank you. And I'm going to again answer that question in a family court context as well. Family court agreements, family court orders from a court, or divorce agreements are enforceable throughout the country, and even enforceable in other countries. And sometimes you need to have those foreign orders registered. But in general, if you have an agreement and it's signed in New York, you know that it's going to be enforceable if you move. The difficulty in family law is you just can't pick up your kids and move without consent or without a court order. And because I am anticipating there's going to be a lot of relocation and disruption after this pandemic, people living from Nassau County moving into another county, or from another state moving into New York, it's very, very important that you understand the jurisdiction of children. And I'm just going to give you something just so that you keep in your mind, because this is such a common question. Unless it's an emergency situation, you cannot file a proceeding in another state unless it's the home state. And home state jurisdiction is 6 months. So for example, if you have a couple living in New York with their children and they have an agreement regarding parenting time and the schedule, if the other parent moves into New Jersey and wants to bring a custody case, they have to wait 6 months. And before that 6-month deadline, the home state deadline, all proceedings have to be brought in New York. We've had a number of very dramatic cases between New York and Israel in our office, where parents move from New York to Israel and then it's a vacation, or they're really moving. And if you wait longer than 6 months to bring jurisdiction in New York, it's going to be a major problem. So this is, again, something where you can't let legal issues kind of fester and escalate without getting advice, because the problems almost always get worse. And it's better to have that advice so that you can make decisions and not regret it later. And when it comes to relocation and the home state issue, you can't really negotiate around it. It's really something that's going to be very, very strictly enforced.
Jacqueline, may I read the next one?
Yes, go right ahead.
Again, it's an anonymous attendee. Hello, great women. Thank you for this very informative webinar, and we all feel the same way. Thank you. If my husband and I lose our life at the same time due to coronavirus or any other reason, what do we need to give my 8-year-old daughter's custody to my brother who lives in New York City? There is also a way to give her custody to my mom, who lives overseas, and send her with her grandma to overseas. She has a valid tourist visa and visited the US several times in the last 20 years. And it continues, it's a multi-part question. Do I need an attorney? What you said about don't download a will from the internet or don't buy it from a store, is this also including this situation as well?
Well, okay, I'm going to answer the custody part of it, and then I'm going to give it to Ann, because I really think this is really more of a guardianship question. In general, and this is why people really need to think about it right now, it is not so unheard of for parents both to get sick. We have gotten many inquiries regarding, how do I change custody? What do I do if my spouse dies or there's a situation with illness? It is a very valid concern right now. That's why we're really doing this webinar. So not to be too pessimistic, it really should be on everyone's mind. What happens if something happens to both me and the child's other parent? So in a general rule, if you have 2 parents sharing custody and they're married, they have joint custody. That child is their child, and they have equally superior rights. They're on the same playing field. In a divorce situation or a separation, if the child lives primarily with one parent and has parenting time with the other parent, generally that's with joint legal custody. If the parent that the child is living with passes away or becomes incapacitated or has other issues, the other parent that maybe only had visitation rights once or twice a month, that parent has primary custody rights. The surviving parent almost always has higher rights than a grandparent, especially a grandparent living out of the country. But the question that we're being asked is, what happens if both parents pass away? What can be done to really provide for an alternate guardian? And I'm going to let Ann address the paperwork or the directives that can be put in place. But before I do that, I just want to make it clear, it's very, very unlikely that a small child is going to be sent out of the country to go live with a grandparent, no matter what the paperwork says. And from what I understand, I think our president just issued an order that immigrants or people can't even travel into the country right now. So that's another problem. The way the court always addresses it in a family court context is what is in the best interest of the child. And it might not be to go live with a grandparent out of the country. And I'm just going to put that out there, which is another reason why parents should really be thinking about who is the best guardian, who do I trust, and really consult with an attorney to help flesh out that solution and put it in writing. And so now, Ann, it's going to be your turn to really give.
Yeah, so we appoint any of us with minor children really should be taken to the woodshed if we don't do something legally and in writing to ensure that there is a guardian in place in the event that both parents are dead. And we do that within the will. We name a guardian, and we can name co-guardians. And in this case, well, let me not speak to this case because I don't know anything about it, but in a hypothetical case where we have a grandparent overseas, I agree with Jacqueline that it's not really plausible that the child is going to go live overseas. But if we want that grandparent to be involved, it is entirely possible to name that grandparent as a co-guardian. Doesn't mean that the child has to physically live with that person, but that co-guardian will have input into major decisions such as education. And in addition to naming a guardian who will have physical custody and a guardian who will have shared legal responsibility for making decisions with respect to the child, we also need to deal with the child's finances. So we said earlier within the will, we want to deal with how our beneficiaries inherit the assets. So if we have a minor child, we need to build a trust for them to have their assets. I cannot name a minor child to receive 1/3 of my estate, and I cannot name, this is the single biggest mistake out there when we're at work or we're with our insurance advisor and they ask who's your primary beneficiary. 9 out of 10 of us will name our spouse. Who are the backup beneficiaries? And we name our 9-year-old, our 10-year-old, and our 12-year-old. That is a big mistake. That family will be in court for more than a year. It's a given. Does anyone remember the Little Rascals and Spanky, Jackie Coogan? Well, he at one time was the most famous person in the United States, and he had an amazing career. When he became of age, he was looking for all of his money, but his parents spent it all. So thanks to those bad parents, every state in the United States has laws that we refer to colloquially as the Jackie Coogan laws. New York State has some of the strongest laws in the United States. So if we name a minor as a beneficiary of an asset or under our will, you can be sure that the court is going to appoint a guardian ad litem to safeguard the child's financial interests. Now, who do you think pays for that guardian ad litem? the child's assets pay for the guardian ad litem. And it's a plum gig if you can get it from the court, because it pays a lot of money, and you can avoid having this, you know, court-appointed vulture on your kid's money by structuring it yourself. And this goes back to, you know, being knowledgeable, empowering ourselves, sharing information. And we want to have a trust for our kids. Maybe it pays out a third at 25, half of what's left at 30, and the full balance at 35. But even prior to those ages, the money can be used for the child, for their education. But because you're not mandating that it be used for education, it does not count against a college financial aid award that the child might otherwise get. So that's the trust. You want to appoint 1 or 2 people as the trustee of that child's trust. And it may be the same person or people you're naming as guardian. It may be different people. Maybe as physical guardian of my child, I'm naming my sister, who's the salt of the earth, and she's wonderful, warm, and nurturing, but she can't balance her checkbook. So yes, I want my child to physically be with her, but maybe I would want the child's grandparent overseas to be the trustee of the finances. So we can split out the roles, and again, it's important that we put some thought into it.
Very good.
Those are excellent questions.
Yeah.
Victoria, I just wanted to respond just very, very briefly on the issue of grandparents' rights, which is, I think, also going to have a little bit of a resurgence when this pandemic is over. And that is because we all know that grandparents love their grandchildren, and children love their grandparents, and oftentimes grandparents are caretakers. And we are seeing so many cases where young people, young parents have lost their lives because of the pandemic or other reasons, or maybe have lost their jobs. As I mentioned before, because of mental illness and substance abuse, we are going to see custody cases based on those issues. And grandparents have a very important role to play when it comes to caring for their grandchildren. And it's very important for everyone to know that grandparents do have rights to grandchildren. They have rights to see their grandchildren, even if both parents object. Very interesting and very important to know, but there has to be a pre-existing relationship, which is called standing. And so, you know, grandparents are very, very loving childcare almost all the time. Is it perfect childcare? I would say no, but it's loving. Children love being with their grandchild. And I'm gonna say again, 80% of the time, there are cases when maybe grandparents really shouldn't be in the picture, but grandparents that are listening, that are concerned about what's going on with their grandchildren, they can be named as joint custodians. As Ann mentioned, they can be named as guardians. And I would think that this is something that parents should keep in mind when it comes to really thinking of creative ways to resolve family conflict, and including custody and child care issues that are for certain going to be part of what has to be discussed in the future.
Can I add something, ladies? We have to be careful, though, when we choose a grandparent. We have to also monitor their health and their capability as time goes on, and we have to revisit and make some adjustments and changes. We can't just put something away and forget about it. Life changes. And as children get older, we have to revisit the will again as they get into their teen years. So it's very important that it's just not done and put away.
Absolutely.
Great point. Not one and done.
Not one and done. And so now, if you would like this PowerPoint and the resources that the 2 law firms have provided, please go to cwny.org/past-events/. And now we at the Center for the Women of New York put together some resources for you. Please don't forget the state and county bar associations. They are here to help our citizens, and they have plenty of resources on their websites. They do offer pro bono services, and they do offer phone-in sessions. Also, not to extend the morbidity of speaking about the pandemic, but we do need to know what happens if our loved one passes away in this time. So on the New York City website, you can learn what is acceptable in this time of pandemic. Things have changed. We have to have social distancing even in times of grief. And if you would like the 8-page healthcare proxy, that's on our New York State Department of Health website. And as Ann-Margaret spoke about, there is a order to not resuscitate for non-hospital situations. But again, don't do these things alone. Please seek the advice of a licensed professional. None of these fly-by-night websites or quick fix solutions on the internet. Don't be trapped. CWNY needs your feedback so we can improve our future educational programs. Please complete this brief survey at this brief link. If you don't have time to copy it now, please go to the PowerPoint on our website. We do appreciate your feedback so we can improve and provide education that is pertinent to you. CWNY is offering a webinar on Tuesday, April 30th at 11 a.m. discussing health and wellness in quarantine. We offer weekly caregivers phone support groups. Please don't do it alone. We in my family are taking care of our elderly fathers, and we have gone through the deaths of our mothers, and it is not easy. And when we share with a licensed professional and with our peers, we can get the relief we need in these difficult circumstances of caring for an older loved one. It's all new to us, and it's very emotional, very stressful. And I'm sure in these times of quarantine, there are new situations that are arising. So please reach out to us. The telephone number is on our website. We also offer conversational English as a second language class once a week, and it will expand as the needs arise. We are planning our computer classes. We are bringing back our legal clinic, where you can come in and get some procedural advice on your legal issues. And as soon as we can, we will start our walking group at Fort Totten. Enjoy the beautiful park, enjoy the beautiful shoreline there and the view of the bridge, and join us. And we will be sending out information on our book club. So, as you know, we are a nonprofit and we depend on the donations and the membership of our members. So please do visit our website and please help us to continue to provide these educational programs. CWNY.org/donations/ or CWNY.org/membership/. We hope you'll join us and we hope you learned something. Thank you. Bye now.
Thank you.
Thank you, Ann.
Bye.
Bye-bye.
Thank you, ladies.
Bye, everyone.